Courts and Crimes Legislation Amendment Bill.
I call the Attorney-General.
Mr Deputy Speaker, I move that a bill be introduced for an act to make miscellaneous amendments to certain legislation with respect to courts, tribunals and crimes and for related purposes.
The question is that this new bill be now introduced. All of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it.
Mr Deputy Speaker, I bring up the bill and I move that this bill now be read a second time. Mr Deputy Speaker, the Government is pleased to introduce the Courts and Crimes Legislation Amendment Bill 2015. This is part of the Government's regular legislative review and monitoring program and makes miscellaneous amendments to legislation affecting the operation of the courts and tribunals of New South Wales and other legislation administered by the Attorney-General and Minister for Justice. I'll now outline each of these amendments in turn. Schedule 1. Schedule 1.1 amends the Children and Young Persons Care and Protection Act 1998 to restrict the proceedings in which a risk of harm report can be admitted into evidence before the New South Wales Civil and Administrative Tribunal. Before NCAT commenced, Section 29 of the Children's and Young Persons Care and Protection Act provided that risk of harm reports could only be admitted into evidence in the Guardianship and Victims Compensation Tribunals. Section 29 was unintentionally widened when the Civil and Administrative Legislation Repeal and Amendment Act 2013 commenced. As a result, risk of harm reports can now be admitted in all NCAT proceedings. Now, while in practice NCAT would only allow these reports into evidence when they're relevant, it is important that the risk of harm reports remain as confidential as possible. This amendment therefore re-establishes the previous position. Schedules 1.2, 1.3, 1.4 of the bill contain 4 amendments to the Civil and Administrative Tribunals Act 2013, the NCAT Act and regulations. These amendments were proposed by the President of NCAT and are minor or technical in nature. The first amendment will allow NCAT to grant leave for a person to be represented by an Australian legal practitioner without specifying that practitioner by name. Currently, the NCAT Act permits leave to be granted to an identified representative only, and this can be inefficient where, for example, a person is represented by legal aid and a different solicitor appears on each occasion. The second amendment will permit NCAT to revoke orders it makes to appoint a person as guardian ad litem for a party to represent a party or a person to be separately represented. There may be situations where it's appropriate to revoke these kinds of orders, for example, if a person is not acting in the person's best interest. The third amendment replaces references to the Health Practitioner Division list with the Health Practitioner list, and this clarifies that there is no Health Practitioner Division of NCAT. It does not make any other substantive changes. The fourth amendment to the NCAT Act will allow senior professional members of the Guardianship Division to sit on internal guardianship appeals. The Act currently doesn't permit these members to hear appeals. This was a drafting oversight, and senior professional members have specialist expertise in guardianship matters and should be permitted to hear internal appeals. Section 1.5 of the bill contains a minor amendment to Section 12 of the Water Act 1912 to correct a drafting oversight. The amendment updates the Water Act to reflect the fact that NCAT is now responsible for making decisions for the purpose of that section. I move to Schedule 2. Schedule 2 concern amendments regarding guardianship. Schedules 1.1 and 2.2 of the bill contain minor and technical amendments to the Guardianship Act 1987 and the Guardianship Regulation 2010 that were proposed by the President of the Guardianship Tribunal prior to its integration with NCAT. The first amendment will ensure that enduring guardians are included as a party to guardianship applications and reviews of guardianship orders. Currently, enduring guardians must make an application for joinder to become a party, despite having sufficient interest to be included as a party, partly and because of their authority to make decisions is suspended by an operation of a guardianship order. This amendment will eliminate the need for those procedural hearings and improve NCAT's efficiency. The second amendment to the Guardianship Act ensures that a person with a power of attorney will be included as a party to applications to review a financial management order or review an appointment of a manager. Presently, attorneys are included in applications for a financial management order but not in applications for a review. An attorney's authority is suspended during the operation of the financial management order and may recommence if that order is revoked. The government considers they have sufficient interest to be included as a statutory party in relation to reviews. The third amendment to the Guardianship Act will replace the term alternative enduring guardian with the term substitute enduring guardian. Currently, the Act allows an instrument of appointment of an enduring guardian to appoint another person to be an alternative enduring guardian who can exercise functions if the original guardian dies, resigns or has an incapacity. The word alternative, though, may be misleading to the public, as it may imply that either the alternative enduring guardian or the original enduring guardian can exercise functions at any time. And so this is clarified by replacing the word alternative with substitute. The fourth amendment to the Guardianship Act 1987 will allow NCAT to proceed as if an application for a guardianship and or financial management order has been made when reviewing the appointment of an enduring guardian without the need to first revoke the appointment. Currently, Section 6K of the Guardianship Act provides that on reviewing the appointment of an enduring guardian, NCAT may either revoke the appointment or confirm the appointment with or without varying the functions of the enduring guardian. When NCAT has decided to revoke the appointment of an enduring guardian, it may proceed as if an application for a guardianship and or financial management order has been made. This amendment will improve Section 6K of the Guardianship Act by providing greater flexibility for NCAT to make decisions in the best interests of the appointer, especially where a guardianship or financial management order might only be needed for a short period of time. The Fifth Amendment to the Guardianship Act allows NCAT to renew and vary a guardianship order when reviewing the order. This amendment addresses situations where a person may request NCAT to review a guardianship order close to the end of the term of the order, and another review would otherwise be required within a short period of time. The Sixth Amendment to the Act will allow people to apply for a financial management order for themselves and provide that a person subject to a financial management order can apply for the review of an appointment of a financial manager. The next amendment to the Guardianship Act replaces a reference to the now repealed Section 68 of the Guardianship Act with a reference to the section that has replaced it, Section 61 of the Civil and Administrative Tribunal Act. The Eighth Amendment to the Guardianship Act will allow for NCAT to review both a financial management order and appointment of the manager at the same time. Presently, a financial management order and the appointment of the manager are considered to be two separate orders, and this causes confusion upon reviews. This amendment will also clarify that the power to vary an order, including the power to insert or remove an exclusion pursuant to Section 25E. This will ensure that a tribunal constituted by fewer than 3 members can insert or remove exclusions upon the review of an order. The ninth and final amendment to the Guardianship Act will allow NCAT to review the appointment of a manager within a specified time. For example, NCAT may appoint the New South Wales trustee and guardian as a manager to resolve a particular legal and financial issue within a review within 12 months if it's considered that a suitable private person could take over once that issue has been resolved. So, Mr Deputy Speaker, overall, the amendments to the Guardianship Act will provide NCAT with flexibility to manage guardianship orders by streamlining the tribunal process, and that will result in improved efficiency. I turn to Schedule 3, amendments concerning acting judicial officers. Schedules 3.1 to 3.8 contain amendments to various court and tribunal acts. Schedules 3.1, 2 and 3, 4 and 7 amend the Children's Court Act 1987, the District Court Act 1973, the Drug Court Act 1998, the Dust Diseases Tribunal Act 1989, the Local Court Act 2007 to enable the Attorney-General to appoint a judicial officer who can act as head of jurisdiction for a particular absence or for any absence that occurs from time to time. All court and tribunal acts contain provisions that govern who is authorised to act as head of court during an absence in office. In some cases, either the Governor or the Attorney must provide a judge with a commission to act. In other cases, default provisions allow the next most senior judge to act if no commission is provided. However, this is not always the case, and this can cause difficulties, especially where the head of court needs to take leave unexpectedly. These amendments will provide the local court, district court, dust diseases tribunal, drug court and children's court with consistent provisions regarding acting arrangements. And I must add, Mr Deputy Speaker, the heads of court support these amendments. Not all court and tribunal acts are being amended though. The Coroner's Court, Workers' Compensation Commission and NCAT already have an equivalent provision. The Chief Justice of the Supreme Court, the Chief Judge of the Land Environment Court and the President of the Industrial Relations Commission advise that amendments are not required in their particular courts. Section 3.2 of the bill contains an amendment to the District Court Act that will allow retired judges of the Family Court of Australia to act as judges of the District Court after they have reached the age of 72. Currently, Section 18(4)(a) of the District Court Act permits retired federal court judges to act as district court judges after they turn 72, as well as retired judges of other state, territory, supreme and county courts. However, there is no equivalent provision for retired family court judges. A number of former family court judges hold commissions as acting judges of the District Court, and these judges currently have leave when they turn, or need to have leave when they turn 72. So this amendment will enable those judges continue to act after the age of 72 until they reach the age of 77. The Chief Judge of the District Court supports this amendment. Schedules 3.2, 5, 6, 7 and 8 amend the Local Court Act, District Court Act, Supreme Court Act, Industrial Court Act and Land and Environment Court Act to enable judges, acting judges, magistrates and commissioners of the Land Environment Court to be appointed for a period of up to 5 years. Currently, acting judges, magistrates and commissioners of the Land Environment Court can only be appointed for 12 months terms, and these appointments can be renewed each year until the statutory age limit is reached. In the local court, district court, industrial court, land environment court, the age limit for judges and magistrates is 75. In the Supreme Court, the age limit is 77, where a judge retires at 72. So this amendment will enable acting judges, magistrates, commissioners of the Land Environment Court to be appointed for up to 5 years. The provision, of course, also still allows acting judges to be given shorter terms than 5 years. In order to authorise 5-year appointments, the statutory age limit for all judges will also be lifted to 77 years. Lifting the acting judge limit to 77 years will enable, I believe, highly talented and experienced judges to keep working when they are able and willing to do so. Mr Deputy Speaker, I turn to Schedule 4 of the bill, other amendments, to quickly speak to those. Amendments I will turn to first relating to the Crimes Administration of Sentences Act 1999. Schedule 4.1 amends that Act to enable information exchange between the Commissioner of Corrective Services and the Commissioner of Fines Administration, and this is limited to information that assists in the exercise of both Commissioners' statutory functions. The amendment will permit Corrective Services New South Wales to disclose certain details about inmates to help the Commissioner of Fines Administration identify which inmates in custody have outstanding fines. The Commissioner of Fines Administration can then take steps to help those inmates, like delaying fine enforcement actions while they are in custody and offering them appropriate payment options. The amendments will also enable Corrective Services New South Wales to help eligible inmates to make arrangements to work off the value of those fines by undertaking certain programs, treatments and counselling in custody through a work and development order under Section 99B of the Fines Act 1996. This is especially important as we know where people have outstanding debts on leaving prison that their chances of reoffending are increased. To achieve this, the amendments are intended to override the Privacy and Personal Information Protection Act 1998, which would otherwise prevent Corrective Services New South Wales from disclosing personal information about inmates for these purposes without their consent. By permitting the sharing of limited information about inmates, this amendment will enable relevant agencies and inmates to identify where there are outstanding fines and to take steps to resolve them. This amendment, I should say, is modelled on a similar provision already in the Children Detention Centres Act 1987. I turn to the Jury Act 1977. Schedule 4.2 of the bill contains amendments to the Jury Act. It will enable Roads and Maritime Services to provide customer identification numbers to the Sheriff's Office for the purposes of determining whether a person should be excluded from jury service. Currently, Roads and Maritime Services is authorised to provide the Sheriff's Office with driver's licence numbers, but these are not always the same as customer identification numbers. So this amendment will enhance the Sheriff Office's ability to identify people who are ineligible for jury service because of their criminal history. I now turn to amendments relating to the Land and Environment Court Act 1979. Schedule 4.3 of the bill before the House contains several minor amendments to the Land and Environment Court Act. The first amendment will add Class 4 proceedings to the classes of proceedings in the Land and Environment Court where a commissioner may assist judges. Class 4 proceedings relate to civil enforcement and judicial review of decisions under planning and environmental laws. The proposed amendment will permit commissioners to assist and advise the judge adjudicate a matter. Commissioners can already do this in classes 1, 2 and 3 of the court, and this amendment will ensure that commissioners can provide their assistance and non-legal expertise to the benefit of the court in appropriate class 4 matters as well. The remaining amendments in the bill to the Land and Environment Court Act in Schedule 4.3 remove several references to repealed legislation in provisions establishing the court's appeal jurisdiction. These references, I would add, are now obsolete, as no relevant appeals can now be brought. I turn to amendments relating to the New South Wales Trustee and Guardian Act 2009. Schedule 4 of the bill contains an amendment to the New South Wales Trustee and Guardian Act to allow the Mental Health Review Tribunal to revoke a financial management order relating to a person who is or was or has now ceased to be a forensic patient if satisfied the person has capacity to manage their own affairs or it's in their best interests. In addition, the amendment will ensure that a financial management order for a person who is or was or has now ceased to be a civil mental health patient can be revoked by NCAT if it is satisfied that the person has the capacity to manage their own affairs or it is in their own best interests. This amendment, Mr Deputy Speaker, was suggested by the Mental Health Review Tribunal, in part by including a reference to forensic patients. It corrects an oversight which occurred when the forensic patient provisions were separated from the civil patient provisions in 2007. It also enables the tribunal to revoke an order where a person remains in a mental health facility but has not yet been discharged. Managing one's own affairs, I know, can be an important step in a patient's rehabilitation, and these amendments go to that policy outcome. The proposal parallels the powers set out in Section 25P of the Guardianship Act 1987. I turn to amendments relating to the Oaths Act 1900. Schedule 4.5 of the bill contains 3 minor amendments to the Oaths Act 1900 and clarifies that New South Wales Justices of the Peace may witness statutory declarations and affidavits for use in tribunals and arbitration in Australian jurisdictions other than New South Wales. Currently, the Oaths Act refers to witnessing non-New South Wales statutory declarations and affidavits for use in court proceedings outside of New South Wales. The Crown Solicitor's Office has advised that the word court in the Oaths Act should not necessarily be interpreted as including a tribunal. So the First Amendment to the Oaths Act clarifies that New South Wales JPs may witness statutory declarations and affidavits intended for use in a tribunal in an Australian jurisdiction outside New South Wales. The Second Amendment amends the Act so that the documents may be witnessed in New South Wales by JPs for the purposes of any arbitration where it's held in New South Wales or interstate. And this clarifying amendment is to avoid any doubt. Section 26 of the Oaths Act currently only authorises JPs to witness statutory declarations interstate where they are required for court proceedings. The third and final amendment to the Oaths Act will authorise New South Wales JPs to witness in New South Wales all types of statutory declarations required for use interstate to ensure that JPs are authorised to witness statutory declarations required for public administrative purposes as well as for court proceedings. These amendments are necessary to ensure that JPs in New South Wales may witness affidavits and statutory declarations required for use in Australian jurisdictions outside of New South Wales. They will also apply retrospectively to any oaths, affidavits or statutory declarations made or witnessed before the commencement of the amendments made by this bill, which is appropriate so there is certainty. I finally turn to the amendments to the Trees Disputes Between Neighbourhoods Act 2006. Schedule 4.6 of the bill contains amendments to Part 2A of the Trees Disputes Between Neighbours Act 2006 to include land zoned rural residential or its current zoning equivalent. Currently, homeowners located in rural residential zone properties have no recourse under the Trees Dispute Between Neighbours Act to minimise the impact of high hedges located on neighbouring properties. The only legal option available to rural residential homeowners is to sue their neighbour under the tort of nuisance, which can involve large financial costs and lots of time. This amendment will enable rural residential homeowners to make application to the Land Environment Court to resolve disputes with neighbours relating to planted hedges that are over the height of 2.5 metres that are causing severe obstruction of sunlight to a window or views. This amendment implements the sole legislative recommendation of the 2013 statutory review of the Trees Disputes Between Neighbours Act. It provides rural residential zoned homeowners with the same legal remedies afforded to homeowners in residential areas, delivering rural residential homeowners with a cost-effective means of resolving disputes regarding high hedges. Mr Deputy Speaker, overall, the amendments in this bill will improve the administration of justice in this state. They will assist the courts and other agencies within the Department of Justice to perform their work more efficiently. And, Mr Deputy Speaker, I commend the bill to the House.